A core, very important component of your estate plan, something called a durable, or sometimes referred to as a financial power of attorney. There's an enormous decision that you've got to make when you get that power of attorney, that durable power of attorney in place. And I'm not talking about who you list in it. I'll explain coming up. My name is Mike Bernard. I'm the host of the Wise Money Show. I'm also one of the certified financial planners right here at Corhorn Financial Group. Make sure you hit that subscribe button, turn on notifications, and smash that thumbs up button. So oftentimes people come in and say, well, I need a will. I need a will, or when we're looking at their entire financial life, all 6 areas, we get to estate planning and they say, oh yeah, I got a will. Well, your estate plan is more than just a will. Even in the most basic situations, a will in a healthcare power of attorney or appointment of healthcare representative that has a HIPAA release in it, sorry for the jargon there, a financial or durable power of attorney is the third document, and then typically a living will, which isn't a legal document, but it is expressing someone's wishes on what they'd want to do. That's a basic estate plan. So no matter your situation, looking at this, I mean, watching this video, that's what you're going to need. That's the estate planning happy meal. You need those four things. If your situation's more advanced, you might need a different type of will. You might need a trust. You might need some other documents. When it comes to then that financial or durable power of attorney, there's an enormous choice that you need to make. And I'm not talking about, well, I've got to, give the authority to someone. No, it's an even bigger decision than that, in my opinion. So how's that work? Okay, a durable or financial power of attorney is a document that legally gives permission, gives authority from you to someone else that they can act on your behalf if you're unable to make your own financial decisions. So in the case, now this is awful and painful, so I'll share it from a personal perspective. When my mom was young, when she was 16 years old, she got hit by a car when she was on her bike, and she was in a coma for I think it was 14 days. She just told me more details about this recently. They came up from Florida to visit and talking about how she had to relearn how to walk. They weren't sure if she'd ever, talk again. Like it was, gosh, I mean, she almost died. I can't imagine what my grandparents were thinking as they were watching their little girl in the coma, wondering if she'd ever wake up. That's a situation where she was a minor. And this was back in, I think it was 1960 something, 1968, something like that. And so they didn't really need to worry about, all the HIPAA rules and privacy laws we need to deal with today. So my grandma and grandpa, they had the express authority to make medical decisions for her when she wasn't able to, when she was in a coma. They also had full access and full authority to make financial decisions. But let's fast forward to today, and let's take this scenario as someone that's not a minor. Take myself. If I were hit by a car and I was in a coma, I would have to give authority to someone else to make medical decisions for me since I'm not able to. That's the healthcare power of attorney, okay? And if I'm married, there might be some rights there, some rules, but with all the privacy laws and how weird things are right now, even that's not, don't take that for granted. Don't assume that that's just automatic. But certainly on the financial side, people can be married and have lots of financial secrecy, okay, and want to keep things separate financially. I'm not suggesting that. Oftentimes we suggest the opposite. You should have things joint. There's reasons for that. But to each their own. Okay, so financially, if you're not able to make your own decisions because you're in a coma, because you have early stage Alzheimer's or dementia, or you're out of the country, or you got COVID and had terrible symptoms, something like that. If you weren't able to make your own financial decisions, the power of attorney, that durable or financial power of attorney, is you stating, here's who I want to make the decision instead of me, okay? And typically, you're going to list your spouse if you're married, you're gonna list someone that you trust completely, right? And then you're gonna want to list at least one alternate. that if that person is also unavailable or says, this is too much pressure or it's too emotional for me, I can't do this, there's someone that is an alternate, okay? So obviously that's a big decision, picking who you would trust to make a financial decision for you if you weren't able. But the big decision I'm talking about is, when does that power of attorney, when does that authorization start? That's a decision you need to make. Most attorneys, most financial advisors don't explain this. Now, I'm not an attorney, I'm not a JD, so this is not legal opinion. I'm just telling you, when you talk to that expert, when you're talking to your certified financial planner and then talking to an attorney, or if you think you can just do this online, which I don't recommend, they oftentimes overlook this big choice. What's the choice? You can choose to have that power of attorney be a springing power of attorney or an immediate power of attorney. So a springing power of attorney or an immediate power of attorney. What's the difference? A springing power of attorney means, here's who I'm giving authority to. If I can't make decisions, this is who I want to make the decision for me. But listen, this thing doesn't even go into effect. It doesn't spring into effect until you can prove that I can't make my own decisions. So if you can prove that I can't make my own financial decisions, then they can make the choice. But listen, if you can't prove it, then they don't have any authority. They don't have any authority. And most people view a power of attorney that way, as a springing power of attorney. And before my eyes were opened, I thought, well, they should all be that way. But the burden of proof, that can take time, and sometimes you don't have time, and it might sometimes be impossible, and you might need someone else to help you with something, even if you can't prove, or you don't absolutely need someone else to do it. So that's springing power of attorney, okay? I'm not talking against it, that's just one of your options. The other is an immediate power of attorney, where that permission, that authority is instant. As soon as I sign my name, these people, this person, can act for me at any time, okay? Now, that takes a lot of trust. So there's pros and cons of each, right? If you're listing someone to have authority on your behalf at any time, you better trust them with your life, because they could go out and open a credit card. They could sign your tax return. They could call your financial planner and say, I need to withdraw some money, right? They've got immediate authorization to make financial decisions for you. So this is the big choice. I'm not saying one's right and one's wrong. This is why I'm saying this is an enormous choice, sometimes possibly even bigger choice than even who you would list there, is when it would take effect, springing or immediate. Talk to your attorney, talk to your certified financial planner about the pros and cons in your situation to see which one makes the most sense. I'll give you a couple scenarios, all right? If you're not married, and you've got some siblings or whomever that you would list as your power of attorney, but you're not really close to them, maybe you don't live near them, but they're the closest of kin, and so you wouldn't want them to be immediate. They're not in your life. They don't know your finances, and so you're not going to be relying on them at a moment's notice. So that definitely should be a springing power of attorney. Okay, here's who I want to clean up the mess if I can't clean it up myself, but they don't get involved until there's a mess, until I can't make decisions on my own. That's a clear case where you'd want to use the springing power of attorney. A clear case when you'd want to have an immediate power of attorney is for your young adult children. Your child's 18, they go off to college, something like that. Something happens to them. Do you really, they're still your child in a way. Yeah, they could go to war, but financially, they're still your responsibility for most people. And if something happens, you would want to be able to step in and help them out at a moment's notice without needing to or having to jump through the hoops to look at different doctors and have doctors write a note or go through the court system to get guardianship, something like that. You would want that most likely to be an immediate power of attorney. For me, I'm married. My power of attorney, my financial durable power of attorney is immediate. So that if I'm overseas or if I'm unavailable and I can't do something, we need to get something done, there's an emergency, Cindy, go ahead and do it. You can sign for me, that's fine. Okay, so obviously that takes a ton of trust. Not every marriage has that level of trust or whatever, but that's the choice that I made. work with your certified financial planner, see what the circumstances are, see what your overall financial condition is, and make this choice yourself. Don't just use a default option that's maybe online or that your attorney is maybe glossing over. So work with your CFP on that. If you don't have a CFP on your team that can help with that, contact one on my team. Find us online, corehorn.com, that's corehorn with a K, wisemoneyshow.com, you can find us there as well, or send us an email, info@corehorn.com. All right, there you have it. Go out and take your next wise step in your financial life.